The Supreme Court of India has delivered a momentous reminder that the Hindu Succession Act, 1956, does not automatically extend to members of the scheduled tribes. This ruling, dated for our present understanding as of October 22, 2025, is not a new law, but a powerful clarification of existing legal boundaries, reinforcing a long-standing principle that has significant implications across the nation. The core of the matter revolves around a single critical question. Does a nationwide statute governing Hindu inheritance rights supersede the ancient, uncodified customs that have guided tribal communities for centuries? The court's answer firmly upholds the sanctity of these customary laws, creating a clear legal distinction that affects property rights, family structures, and gender dynamics within these protected communities. This judicial pronouncement did not emerge from a vacuum. It addresses a recurring ambiguity that has often led to legal disputes within tribal families and communities. The central conflict arises from the desire to apply a modern, codified law intended to bring uniformity and gender equality to societies that operate under entirely different social and legal paradigms. To fully grasp the significance of the Supreme Court's ruling, one must first understand the Hindu Succession Act, 1956. This act is a comprehensive code that governs inheritance. Hindus, Buddhists, Jains, Sikhs. Before 1956, inheritance was dictated by traditional schools of Hindu law, complex, varied by region, overwhelmingly patriarchal. The 1956 Act was revolutionary. It standardized rules and introduced uniformity. It granted property rights to women previously denied. Its primary function: provide a clear order of succession when there's no will. It lays out a hierarchy of heirs. It details who inherits and in what proportion. It establishes coparcenary within a Hindu undivided family. The 2005 amendment granted daughters the same coparcenary rights as sons, a monumental step toward gender equality, aimed to dismantle financial dependency and empower women. Scheduled tribes are communities that are explicitly recognized by the Indian Constitution, social, cultural, economic. They are listed in a schedule under Article 342, hence the name. These indigenous communities are considered to be the original inhabitants of the land and have historically lived in geographical isolation, often in hills and forests, maintaining a way of life that is markedly different from the mainstream population. Their social structures, cultural practices, languages, systems of governance are diverse and have been preserved over millennia, forming a rich tapestry of India's human heritage. The Constitution provides them with special protections to safeguard this distinct identity from being eroded by assimilation. The primary reason for affording special status is to protect them from social injustice and all forms of exploitation. Historically, these communities have faced marginalization, dispossession of their lands, economic disadvantage. To counteract this, the Constitution provides for reservations in legislative bodies, government jobs, and it establishes mechanisms to protect their rights to land and resources. The core idea is not to keep them isolated forever, but to empower them and enable their development in a manner that respects their cultural integrity and allows them to join the national mainstream on their own terms without losing their unique identity in the process. That's the protective rationale. The Supreme Court's reasoning for reaffirming that the Hindu Succession Act does not apply to scheduled tribes. The judgment hinges on Section 22, which carves out an exception for scheduled tribes. The statute's language is unambiguous. The Act creates a default exclusion which can only be changed by the central government via a notification in the official gazette. Without that notification, the exclusion stands. The court tied its view to constitutional protections for scheduled tribes. Constitutional protections: 5th Schedule, 6th Schedule. Those schedules grant autonomy over governance and customary law. Imposing the Hindu Succession Act would override that scheme. Tribal customary laws are not a legal vacuum. They are a living system of jurisprudence. Those customs dictate inheritance and function as law for members. Displacing them without a clear mandate risks chaos and dispossession. The court kept customary laws intact until legislature or executive acts. The Hindu Succession Act, especially the 2005 amendment, advances gender equality, but applying it to tribal societies could backfire. For example, in matrilineal tribes, women already hold significant property rights. applying the act could dilute that status. The court urged reform through consultative, legislative processes, not judicial fiat. The practical effects of this ruling are immediate and tangible, directly influencing how property is managed and inherited within India's tribal communities. The most direct consequence is that the succession of property, especially land, will continue to be governed by the specific customary laws of each tribe. This means there is no single uniform rule. For example, consider a member of the Ho tribe in Jharkhand. Upon their death, inheritance of their land will not be determined by the Hindu Succession Act's provisions for equal shares among sons and daughters. Instead, it will follow the Ho community's traditional practice, which may favor male lineage for the preservation of ancestral land within the clan. This preserves immense diversity. In some communities, property passes through a matrilineal line, such as the Khasi and Garo of Meghalaya, where the youngest daughter often inherits ancestral property and cares for parents and land. In contrast, patrilineal tribes like the Santals of eastern India may traditionally exclude daughters, passing land to sons. This reality places a burden on parties and courts to ascertain and prove specific customary law. Unlike a codified statute, custom is often unwritten and must be established through elder testimony, historical records, and authoritative texts. Government officials and revenue departments cannot assume HSA principles apply to inheritance changes. They must be trained to understand local customs. This complicates accurate land records crucial for bank loans, agricultural subsidies, and other benefits, reinforcing the need for decentralized, culturally sensitive land administration that integrates traditional knowledge with formal systems to prevent disputes and ensure justice. The Supreme Court's clarification casts a sharp spotlight on the complex and often precarious position of women regarding inheritance rights within scheduled tribes. While the ruling preserves cultural autonomy, it also means that tribal women cannot automatically claim the gender-equal inheritance rights guaranteed under the Hindu Succession Act, 2005. Their rights remain tethered to their community's customs, from highly equitable to deeply discriminatory. This creates an uneven landscape where a woman's access to land is determined by ancestral tradition, not national statute. In many patrilineal societies, customs exclude women from inheriting land to prevent alienation outside the clan, fearing a daughter will take land upon marriage. In several central and eastern Indian tribes, sons inherit land, while daughters have a right to maintenance until marriage. Courts cannot use the HSA to override such customs. Conversely, the ruling protects strong matrilineal rights in Khasi, Garo, and communities like Narikudi, where lineage and inheritance traced through the mother and women are custodians of ancestral property. Applying equal division rules could paradoxically weaken women's status by assigning shares to male heirs who traditionally held none. Ultimately, gender justice within tribal communities remains in flux, calling for future legislative action and social reform. While custom is protected, it is not immune from constitutional principles of equality and non-discrimination. Customs blatantly unjust or opposed to public policy can be struck down, enabling case-by-case challenges. The next step is nuanced dialogue, engaging tribal communities to encourage internal reforms, and where necessary, carefully crafted legislation that strengthens women's property rights without erasing the cultural fabric of these unique societies.